In a farewell speech on August 19, 2021 to the Madras High Court on the occasion of his retirement from the court, Justice N. Krubakaran, a senior and much loved and respected judge of the Madras High Court, said something of importance for judicial education. Let's listen to what the retiring judge had to say.
Knowing too much of citation would destroy judges' independence approach in deciding the cases. Lawyers are supposed to know law more than the judges, who would get required and relevant precedents while arguing the case.
Justice Krubakaran's argument, as I understand it, appears to rest on the understanding that the judge's responsibility is simply to settle the dispute between the parties based on whatever facts and law the parties present to the court, guided, of course, by the judge's conscience, his own or her own sense of right and wrong. Any personal understanding or knowledge of the law brought into the adjudication of a case by the judge would necessarily end up helping one or other party's case and could thereby compromise the perception of independence and neutrality of the judge. In another part of his speech, Justice Krubakaran says he decides the matters before him based on his conscience. Needless to say, the view that emanates from his conscience, such as it is, will also eventually end up helping one party or another in a case as much as any extra knowledge of the law on the part of the judge. Yet, Justice Krubakaran seems to see this application of the judge's own conscience, his own sense of what is right or wrong, as a sign of independence rather than as a factor that would adversely affect the independence of the judge. This is how I understand Justice Krubakaran's argument. Now, if, on the other hand, we take the view derived from the Evidence Act's definition of fact and issue, that the role of the court in a litigation is to determine the existence, non-existence, nature, or extent of right, liability, or disability asserted or denied by the parties in a proceeding, then surely that determination has to be made on the basis of an accurate, precise, and complete understanding of the applicable principles of law. Where this is not offered by the parties, the judge should have the responsibility and the knowledge to make sure that the decision is not compromised and that the decision is made on the basis of accurate, precise, and complete understanding of the applicable principles of law. In the common law adversarial system, juries typically are the decision makers, not judges, on proof of facts as well as on guilt or innocence. And the judges, not counsel of the parties, have the duty to advise the jury on the applicable principles of law. The abolition of this separation of roles between jury and judge in India has resulted in judges avoiding, as in this case, excessive knowledge of law so as to be neutral and independent, and thereby creating a systemic vulnerability that there's no one in the adjudication system responsible to ensure that the correct, accurate, complete set of principles of law that are applicable to the case are followed in the adjudication, which in turn potentially results in erroneous decisions and the need for appellate review, which is available only for a small segment of the population that can afford to take a case up. Justice Krubakaran's open and honest discussion of the judicial method he follows is, of course, to be much appreciated. It helps us understand how our judicial system works and how we should seek judicial reform to better meet the needs of society and of a changing world.